Hello students, this is Dr. Rajmugli Amirishetty, practicing company secretary, corporate legal advisor and insolvency professional. Being insolvency professional and also author of book on lectures on insolvency and bankruptcy laws, I am confident to present this topic properly and I am also glad to be part of this knowledge sharing mission. Let me reiterate that the object of Insolvency and Bankruptcy Code is to provide insolvency resolution of corporate persons, partnership firms and individuals in a time bound manner for maximization of value of assets of such persons. We have discussed in earlier lessons insolvency resolution of corporate persons, that is companies and limited liability persons. In this part of lesson, would like to dwell up into various aspects of insolvency and bankruptcy for individuals and partnership firms, that is partnership firms either registered or unregistered partnership firms and personal guarantors to the corporate debtors. Now, we are using the word bankruptcy in this part as against the word liquidation in part 2. Therefore, we need to understand the difference between bankruptcy and liquidation. Liquidation inter alia means closing or winding up of a legal entity through legal process on account of its inability to pay debts. Hence, the liquidation is associated with part 2, that is companies and LLPs, and bankruptcy word is associated with part 3, that is individuals and partnership firms. On liquidation, a company ceases to exist. However, the individual does not cease to exist on going bankrupt. In fact, on bankruptcy, individual and businesses pay back all or part of their debts. It may be noted that the declaration of an individual or partnership firm has a serious and long effect on their credit, thereby affecting the ability to avail credit with favorable rates. The provisions relating to insolvency resolution and bankruptcy for individuals and partnership firms are dealt in part 3 of IBC under sections 78 and 187, consisting of 7 chapters. Part 3 also deals with personal guarantors to corporate debtors. This provision has been enforced from 1st December 2019. It is pertinent to mention that provisions covered under part 3 of IBC are not notified as on today. Therefore, this subject is still governed by Presidency Towns Insolvency Act 1909, that is applicable to Mumbai, Kolkata and Chennai, and the Provincial Insolvency Act 1920, which is applicable to rest of India. Let us hope that this part 3 notified at the earliest. In anticipation of its enforcement, let us discuss the detailed provisions of this part 3 of the code, as it will have far reaching effect once enforced. However, provisions pertaining to personal guarantors covered under this part are enforced effective from 1st December 2019. This part of the lesson is divided into 3 parts, that is part 1, insolvency and bankruptcy of individuals and partnership firms. 2, insolvency and bankruptcy of personal guarantors to corporate debtors and adjudicating authority for individuals and partnership firms. Now, let us discuss about the various stages of insolvency and bankruptcy of individuals and partnership firms. They are mainly divided into 3 distinct parts, that is fresh start order, which is called FSO, entitling an individual to start afresh, failing which the second stage follows, that is insolvency resolution process, failing which ultimately the bankruptcy resolution process will prevail. Now, let us first discuss about the fresh start order. The provisions regarding FSO, that is fresh start order, are governed under section 80 to 93. In this process, individuals with assets and income lower than specified amounts are made eligible to discharge from qualifying debts. Their debts are written off, giving debtor a fresh start. This process exists as an alternative to the insolvency and bankruptcy process. Certain restrictions on applicability of fresh start process have been provided to avoid abuse of this process. Now, let us discuss about the applicability of these provisions. The provisions apply where the amount of default is not less than rupees 1000. However, central government may by notification specify the minimum amount of default of higher value which shall not be more than rupees 1 lakh. Now, let us understand who can make an application. An individual may either personally or through resolution professional file an application for fresh start process with debt recovery tribunal if such individual's gross annual income does not exceed rupees 60,000. That is the first criteria. His aggregate value of assets does not exceed rupees 25,000 or his aggregate value of qualifying debt does not exceed rupees 35,000 and he is not an undischarged bankrupt. He does not own any dwelling unit whether encumbered or not. Fresh start insolvency and bankruptcy process is not subsisting against him and previously no fresh start order has been made in relation to him in the preceding 12 months. It may be noted that the amounts stated above are very less and only few individuals will be eligible. After the eligibility, the next thing is what should be the contents of the application. The following documents supported by an affidavit to be enclosed along with the application, that is list of all debts owned and names of the creditors, interest payable on debt, list of securities held in respect of any debt, financial information about himself and immediate family for period 2 years, particulars of debtors, personal defaults, the reasons for making the application, particulars of known legal proceedings and confirmation that there has been no fresh start order in preceding 12 months of this application. Once application is filed, interim moratorium period commences. This means no legal proceedings can be initiated against such applicant and all existing proceedings shall be stayed. Now, the application can be filed through a insolvency resolution professional or by the debtor directly. Therefore, the process of appointment RP is as follows. Where application is filed through resolution professional, adjudicating authority for the purpose of part 3, adjudicating authority is DRT, that is Debt Recovery Tribunal, shall direct Insolvency and Bankruptcy Board of India, IBBI, within 7 days of receipt of application to confirm if there is any disciplinary proceedings pending against such resolution professional named in the application. IBBI shall communicate such details within 10 days of receipt of such application. Where the application is filed by the debtor directly, adjudicating authority shall direct IBBI within 7 days of receipt of application to nominate a resolution professional. IBBI shall nominate resolution professional within 10 days of receipt of such application. Once resolution professional is appointed, he examines the application and within 10 days of appointment submits a report to DRT, that is adjudicating authority, recommending acceptance or rejecting such application. Now, based on the application, the DRT, that is adjudicating authority, may pass an order within 14 days of the receipt of application. The order shall state the amount admitted or rejected. A copy of the order passed shall be sent to the creditors within 7 days. Upon admission of application, moratorium commences. After commencement of the moratorium, no legal proceedings can be initiated and existing legal proceedings are stayed. Now, the applicant shall not act as director. He shall not dispose of any assets. He shall not travel outside India except with the prior permission of DRT. Moratorium ceases at the end of 180 days of admission unless order admitting the applicant is revoked by the DRT. The final list. The resolution professional shall prepare a final list of qualifying debts and submit such list to DRT at least 7 days before the moratorium period comes to an end. Final order. Adjudicating authority may pass a discharge order at the end of the moratorium period for discharge of the debtor from the qualifying debt and file discharge order with IBBI for its records. The individual, after declaration of the discharge order, can now start a fresh life after discharge order is passed. In case if the fresh start order fails. Now, the second process is the insolvency resolution process. Now, let us discuss the provisions regarding insolvency resolution process covered under section 94 to 120, which involve a process of negotiation between the debtor and creditors supervised by the resolution professional. Then who can file the application? Both the debtor or creditor may file an application. The debtor may initiate application after either personally or through a resolution professional. It may be noted that the debtor is not entitled to make an application if he is an undischarged bankrupt, undergoing fresh start process, undergoing an insolvency resolution process, undergoing bankruptcy process, or if his application to initiate insolvency resolution process was admitted during the preceding 12 months prior to the date of application. Where the debtor is a partner of a firm, such debtor shall not apply in respect of firm unless all or a majority of the partners of the firm file application jointly. A creditor may initiate application either by himself or jointly with other creditors or through a resolution professional. If the application is against partnership firm, the application can be against any one of the partners of the firm or the firm. The application shall be accompanied with the details and documents relating to the debts owed to the creditor on date of application and evidence of failure by the debtor to pay debt within 14 days service of demand notice. When the application is filed, an interim moratorium period will commence. Regarding the appointment of resolution professional, the same process as discussed in the fresh start process to be followed. Now, admission and rejection of application. Resolution professional examines the application and within 10 days of his appointment recommends accepting or rejecting the same. DRT within 14 days of receipt of the report from resolution professional pass the order either admitting the application or rejecting the application. When the application is admitted, DRT on the request of the resolution professional issue instructions for the purpose of conducting negotiations between the debtor and creditors for arriving a repayment plan. When the application is rejected, the DRT shall record the reasons for rejection. Moratorium and public notice. Where DRT admits the application, moratorium shall commence and ceases to have effect at the end of 180 days. Adjudicating authority shall issue a public notice within 7 days of passing the order, inviting claims from all the creditors to be submitted within 21 days of such issue. Resolution professional may call for meeting of creditors after 14 days but before 28 days by giving notice of 14 days, and at the creditors meeting, creditors may approve, modify, reject the plan. When the resolution professional is of the opinion that meeting of the creditors is not required, he shall record the reasons. Where the meeting of creditors is not summoned, the DRT shall pass an order on the basis of the report prepared by the resolution professional. DRT may reject or approve the repayment plan. Where the resolution plan is approved, the resolution professional shall supervise the implementation of the plan. Once completed, resolution professional may apply for discharge of the debtor. Where the DRT rejects the plan, debtor or creditor shall be entitled to file application for bankruptcy. Now, let us discuss regarding the bankruptcy process. The provisions are covered under section 121 to 148 of the IBC. It may be noted that the law of bankruptcy does not expect the debtor should always be the slave of the creditors. The object is to release the debtor at the appropriate time. As seen from the scheme of the code, resolution and not liquidation or bankruptcy is the main object of the IBC. Only upon failure of the fresh start process or insolvency process, a debtor or creditor can make an application seeking an order for declaration of bankruptcy of individual or partnership firm. Thus, when the insolvency process fails, the matter is dealt under bankruptcy resolution process, which is led by the insolvency professional. For this process, he is called as bankruptcy trustee. It may be noted that for corporates, this process is called liquidation, and where the insolvency professional is called liquidator. Now, let us understand the process involved for insolvency resolution process. The applicant can be filed by the debtor or creditor jointly or individually within 3 months from the date of the order passed by DRT rejecting the insolvency plan. And once the application is filed, interim moratorium shall commence on making of application, which shall operate against all the partners of the firm in case of the firm. Transfer of the property by bankruptor between the date of application and up to the commencement date is void and do not give any right to any person, even he obtained property in good faith for value without notice of filing of application for bankruptcy. Now, bankruptcy trustee, the resolution is professional, is termed as bankruptcy trustee to take up the bankruptcy resolution process. The process for appointment of resolution professional is same as discussed in the fresh start process. The DRT shall pass bankruptcy order within 14 days of receiving the confirmation. A copy of the order is provided to creditors within 7 days of passing the order. Upon bankruptcy order, the estate of bankrupt vests in bankruptcy trustee to be divided amongst his creditors. Where the bankruptcy order is passed on application of creditor, the bankrupt, that is debtor, shall submit a statement of his financial position to bankruptcy trustee within 7 days from the bankruptcy order. The certain assets should be deemed as the excluded assets and should not be included in the bankruptcy trust estate. That is, excluded assets, property held by the bankrupt on trust for any other person, sums due to workmen or employees from the provident fund, pension, gratuity fund, and such other assets as may be notified by the central government. The bankruptcy trustee within 14 days of commencement date prepare a list of creditors and within 21 days call meeting of creditors. Trustee shall be the convener and shall decide the quorum and not adjourn the meetings of the creditors for more than 7 days at a time. Bankruptcy trustee shall submit the report on a state of bankrupt in the meeting of creditors. Creditor shall consider the report within 7 days of the receipt of the report and determine whether debtor can be released or not. Now, after the passing of an order, the assets of the debtor shall be distributed in the following order. That is, first the amounts, firstly the cost and expenses incurred by the bankruptcy trustee for the bankruptcy process in full ought to be paid, and then the workman dues for the period of 24 months preceding bankruptcy commencement date and debts owed to secured creditors. Thereafter, the wages and unpaid dues owed to employees for more than 12 months preceding the commencement date, and then the amount due to government for 2 years preceding the bankruptcy commencement date, and thereafter the remaining amount shall be paid to any other debt and dues owed by the bankrupt, including to unsecured creditors. Any surplus remaining after the payment of debts, as discussed, shall be applied in paying interest on those debts in respect of the periods during which they have been outstanding since the bankruptcy commencement. Discharge order. The trustee shall apply to DRT for discharge order on the expiry of 1 year from commencement date or within 7 days of approval of completion of administration. Bankrupt shall be disqualified from being appointed as trustee for any trust, being appointed or acting as public servant, being elected to public office, or being elected as a member of any local authority after declaration or as bankrupt. Now, let us get into the insolvency and bankruptcy process for personal guarantors to corporate debtors. The Insolvency and Bankruptcy Board of India issued regulations conferred with powers by clause T of subsection 1 of section 196 and clause ZR and ZS of subsection 1 of section 240 read with clause E of section 2 and section 60 of IBC 2016 to conduct insolvency and bankruptcy against personal guarantors to corporate debtors via Gazette notification dated 20th November 2019, which became effective from 1st December 2019. The regulations issued in this connection are Insolvency and Bankruptcy Board of India, Insolvency Process for Personal Guarantors to Corporate Debtors, Regulations 2019, Insolvency and Bankruptcy Board of India, Bankruptcy Process for Personal Guarantors to Corporate Debtors, Regulations 2019. By virtue of the above, insolvency and bankruptcy can be initiated against the personal guarantors to corporate debtors. The processes laid down in the above regulations are similar to the processes discussed in this part against individuals and partnership firms. The insolvency professional in the above cases can be appointed as resolution professional or bankruptcy trustee. Now, let us discuss the adjudicating authority for this part 3. It is important to reiterate that the adjudicating authority for individuals and partnership firm, that is for part 3, is Debt Recovery Tribunal, that is DRT. On the other hand, the adjudicating authority for corporate persons is the NCLT, National Company Law Tribunal, for part 2 of the code. The rationale behind this variation is that DRTs are more in number and therefore assigned this role because after enforcing part 3, the cases pertaining to individuals and partnership will be more in number. However, there is a need to strengthen DRTs to equip to deal with these cases once part 3 is notified. Now, any person aggrieved by the order of DRT may prefer an appeal to DRAT, Debt Recovery Appellate Tribunal, within 30 days. However, DRT may allow another 15 days time if it is satisfied that a person was prevented by sufficient cause from filing an appeal. Further, it may be noted that no civil court or authority shall have jurisdiction to entertain any suit or proceeding which falls under the jurisdiction of DRT or DRAT. No injunction shall be granted by any court, tribunal or authority in respect of action taken in pursuance of the powers conferred under the DRT or DRAT. Expeditious disposal of the applications. Where application is not disposed of within specified period, DRT, DRAT, as the case may be, shall record the reasons for not doing so within the period so specified, and after taking into reasons recorded may extend the period but not exceeding the maximum of 10 days. Appeal to Supreme Court. Any person aggrieved by the order of DRAT, that is Debt Recovery Appellate Tribunal, may file an appeal to the Supreme Court on question of law arising out of such order within 45 days, and Supreme Court may allow another 15 days if it is satisfied that the person was prevented by sufficient causes from filing an appeal within 45 days. Hi students, we have discussed in the previous lessons about the genesis of insolvency bankruptcy law, objectives and scheme of IBC, salient features and challenges in implementation of the code. We have discussed about the detailed process of insolvency and liquidation of corporate persons, insolvency and bankruptcy process of individuals and partnership firms. It is pertinent to mention that we have also discussed about the pre-packaged insolvency resolution process in detail. In the next two lessons, we will be discussing about the regulation of insolvency professionals, agencies and information utilities and offences and penalties under this code. Friends, I would like to emphasize that the part 2 is enforced, and because of the enforcement of the part 2, now the economy has come in order and disciplined, and as I said earlier lessons also, more than 4.5 lakh crore has been recovered by the financial creditors, that is the banks, which is the very important aspect. Now, once the part 3 is not enforced, as we know, but once the part 3 is enforced, there will be lot of discipline in the market for the individuals and the partnership firms. Let us hope that the part 3 is enforced at the earliest to bring in social discipline amongst the individuals and partnership firms and enable these individuals and partnership firms to have the financial discipline. Thank you, students.